Should an Illinois law limiting where Illinoisans can sue the state on constitutional grounds be limited to just 2 of the 102 counties in the state? That's a question the Illinois Supreme Court was asked to take up yesterday. Good morning, Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell to get videos updating you on what's going on, news clips, interviews, and more. All right, so let's tackle this. Last year, the state of Illinois passed a measure that limits where individuals can sue the state on constitutional grounds, and that got challenged in a couple of different ways. One, a lawsuit from Piasaw Armory that was actually challenging a different firearms regulation law here in Illinois, dealing with the firearms industry, the Responsibility Act, if you recall that law. So Piasaw Armory sued the state in, I believe, Madison County, and the state has a law that says you can't sue outside of Sangamon or Cook County when challenging the constitutionality of state statute. So part of the Piasaw Armory's law against the Firearm Industry Responsibility Act included challenging this law, saying that you can't sue outside of Sangamon or Cook County. So that's the issue that went in front of the Illinois Supreme Court after lower courts said, yeah, the state law is limiting the individual's ability to access the courts in their home district. So the lower courts sided with Piasaw Armory in this. So the state went ahead and appealed directly to the Illinois Supreme Court. And yesterday they had oral arguments in this case with Deputy Solicitor General Alex Hemmer starting things off in front of the court and really just encapsulating what they say is the crux of this case.
The circuit court in this case held that one of those venue rules, Section 2101.5 of the Code of Civil Procedure, violates due process principles by requiring that some civil cases challenging state statutes and regulations on constitutional grounds, be brought in Sangamon or Cook County. The circuit court did so on the thinnest possible record. 2 declarations asserting that it would be more, quote, convenient to litigate this case in Madison County than here in Sangamon County, an additional hour away. That showing cannot be enough to establish that a venue rule violates the Due Process Clause. If affirmed, the circuit court's opinion would pave the way for due process challenges to every venue rule in the Code of Civil Procedure.
So that's the argument the state made. If they find this law unconstitutional, then it's going to send shockwaves throughout where there's venue limitations for administrative challenges. And that's where you say have like a certain type of permitting issue with a agency, and you're going through administrative process, and there are certain rules as to those types of cases. Attorney Thomas Magg for Piasaw Armory, he touches on that a bit, but is still the state up talking to the justices. Here's Justice Scott Neville Jr. asking a pointed question about why the state thinks that this law should survive.
Well, your opponent argues that the Attorney General has attorneys throughout the state, so it wouldn't inconvenience you to defend in another county, would it?
Of course, and that's true. We do have regional offices across the state, and so we're really not here kind of relying on the sort of difficulty to our office. But the General Assembly looked at this problem, and it concluded that the kind of most reasonable response to it was to take this litigation, which was being filed in sort of these disparate courts across the state, and bring it to courts that had substantial experience.
So a substantial experience, the judges in Sangamon and Cook County are expected that they have the experience to deal with these types of challenges, not the judges in Macon County or Pike or Union County, as Justice David Overstreet points out.
But what about, say, someone lives in Union County?
Mm-hmm.
Isn't it arbitrary and unreasonable to make them come to Sangamon County to make their constitutional argument? In the case of someone who lives in, say, the Second Circuit, okay, why is it not unreasonable or arbitrary to say somebody who wants to challenge the constitutionality of a statute, they live in the Second Circuit, they've elected their own judges in the Second Circuit, that's 12 counties, so it's not just one. The judges they have elected, one of those judges should not hear this. Why is that? Instead, a judge in Sangamon County or Cook County, instead of one of the judges that citizens of one of these circuits have elected. Why is that not unreasonable? Why is that not blatant forum shopping?
So again, those are arguments that Republicans had made in opposition to this law before the bill passed and the governor signed it. That these taxpayers, citizens of Illinois, challenging state law on constitutional grounds should be able to bring their challenges to a court jurisdiction in their backyard, where their tax dollars go and where their votes for judges go. So obviously an interesting argument, but the state pushed back and they talked about all the various challenges to the state's gun ban. If you recall, Attorney Thomas DeVore had 7,000 plus plaintiffs with temporary restraining orders in place in counties all across the state. I remember covering that, and it was every day seemed that there was a different county that was ruling against the gun law. And then you have all the COVID-19 challenges. Again, some cases that Attorney Thomas DeVore brought out that were challenging Governor Pritzker's orders to close schools or to limit economic activity or mask mandates and such. Justice Mary Jane Teese, the Chief Justice of the Illinois Supreme Court, she talked a little bit about how when that happens, the Supreme Court can consolidate these types of cases.
The various challenges to the assault weapon ban and then also the Safety Act. And I maybe would also think of some of the COVID litigation as well. So there were challenges in each one of those cases, and what you say is, and the record will show that, is that those were filed all over the state. And am I correct that what happened was those cases were consolidated, so there would be one opinion in each one of those cases?
One of the kind of words, the phrases that is being thrown around in this litigation, I'm sure you'll hear plaintiffs' counsel use this, is sort of forum shopping or venue shopping. I do think the COVID cases are a good example of why that is not true. There are the good and, the Sangamon County Circuit Court took a very serious look at those cases when they were brought. Our office did not prevail in all of those cases. In fact, we suffered multiple defeats. So I do not think this is a case about forum shopping, trying to get a favorable forum, a judge that's going to side with us. This is about trying to, as the General Assembly explained, consolidate and centralize and make more efficient constitutional litigation.
So how these cases work in oral arguments, the person bringing the case to the court starts, the person responding to that follows up, and then there's a rebuttal from the person who brought the case. So the state had to bring this case to the Supreme Court because the lower court said, no, this law is unconstitutional. So they skipped the appeals court and went right to the Illinois Supreme Court. So they started off the arguments, but then Thomas Magg, representing Piasaw Armory, got in front of the justices and discussed what he says is a fundamental issue in all of this. And Elizabeth Rochford, a justice of the Supreme Court, and Magg go back and forth about this particular question.
Yes, ma'am.
So a ruling in your favor, would it potentially call into question the numerous other venue statutes that are related to agency decisions? What impact would it have?
I don't believe it would have any effect whatsoever on any other existing venue statute, especially none that deal with agency decisions, because as I stated earlier, those are appellate decisions. Those are the equivalent of, there's already been an administrative record created somewhere with presumably fact witnesses' testimony, and what's being decided by the trial, what would be a trial court, a circuit court, is they're acting as a court of appeals, not as a trial court. And I see that as substantially different than what was being done here, is that we're limiting the trial court to only 2 counties.
So again, limiting somebody being able to get in front of a jury in their home county and litigate these things. Obviously, a question the Illinois Supreme Court is having to undertake. Now, talking about the inconvenience of having to travel from southern Illinois to Sangamon County, or having to travel from far western Illinois to Cook County to actually litigate a case, you got to think about all of the logistics there. But also, the Supreme Court seems to be taking into consideration modern technology, telephonic hearings, being able to get on Zoom and have hearings that way. And they've set up all kinds of rules for that. Justice Mary Kay O'Brien asking Magg about the technological advances and how that plays into the equation here.
Earlier, Justice Holder-White asked a question about, should we consider now the advances in technology in terms of making it easier to litigate from anywhere, no matter where venue is established. Should that be something that we should consider, that their times have changed and, your clients could be able to participate remotely?
If we were talking about a case from the 1800s, before modern automobiles and interstate highways, I would probably say yes. But that's not what we're talking about. We're talking about remote appearances, Zoom, that kind of thing. And perhaps it's fortuitous that I grew up in a legal family, and one of my earliest memories is my grandfather sitting at his kitchen table doing an evidentiary hearing, or not an evidentiary, an argument with I believe it was Judge Foreman, who was a federal judge, from his kitchen table on the phone. So, I mean, remote appearances have been around with us in some form for decades. But in my personal experience, the actual evidentiary hearing is something that is best done in person. Remote appearances are dandy for status conferences, for relatively minor affairs, to save drive time for managing the docket. But when you're presenting to a jury or a judge actual evidence, and you're having a witness authenticate documents, in my personal experience, nothing beats or nothing is better than just being there, handing the witness the document, and there's no art. Can you flip through the computer and having technical problems with different people having different versions of Zoom, and some person's technical skills not being the same as others. Being there solves all of that. And so, no, I don't think the fact that in some circumstances, remote appearances like through Zoom are available should change the analysis one iota.
So again, Thomas Mag sharing his thoughts about the idea of remote hearings and how that is either doable or not doable, and what the preferred outcome is for the people bringing the case here. Piasaw Armory, they want this venue limiting law struck down. So hearing some of the questions from the justices, interesting to see what kind of outcome we'll get. Will the justices say, no, this law went over the top? And that would be another law that Governor J.B. Pritzker is found to have enacted that's not constitutional. So we'll have to wait a few months to see what happens there. But another thing people are definitely going to be pointing out in this case is that you had Justice Rochford and Justice O'Brien taking part. You just saw two of their questions asked during oral arguments. They did not recuse themselves, as some may argue. I don't think that was part of this case, at least with legal briefs, but we've seen other cases where indeed, Rochford and O'Brien were asked to recuse themselves because they received $1 million each from Governor J.B. Pritzker when they were running for the Illinois Supreme Court. Lot to tackle. All right, it's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and be with us each and every weekday morning here with America's Talking Network.